The webinar today is titled Serious Misconduct and Summary Dismissal. The working title is Does the Punishment Fit the Crime? As I said, my name is Naylor and I have significant experience in both the government sector. I worked for Queensland Health for a number of years. I worked for the Department of Employment and Training. I worked in the not-for-profit sector at the Churches of Christ, and I also worked for Catholic Education. Over that period of time, I've conducted a number of workplace investigations. Today, this is the outline of the topics that I will cover today. A definition of serious misconduct and summary dismissal. The elements of serious misconduct and summary dismissal. What the Fair Work Commission would look for if it were asked to review summary dismissal, which may have ended up in a Fair Work matter. What are the risks? What is natural justice and procedural fairness? The show cause process. A decision to terminate employment, and finally conveying the final decision to terminate employment. The Fair Work Act of 2009, particularly at Regulation 107, defines serious misconduct as follows. Serious misconduct is conduct that is willful or deliberate and that is inconsistent with the continuation of the employment contract. It is also conduct that causes serious and imminent risk to the health and safety of a person or the reputation, viability or profitability of the employer's business. Serious misconduct can include theft, fraud, assault, intoxication at work, and the refusal to carry out lawful and reasonable instructions or directions consistent with the employment contracts. These elements can be separate things which may constitute serious misconduct and may result in summary dismissal. In situations like this, where an employee is dismissed summarily for serious misconduct, the Fair Work Commission may be asked to rule if any subsequent dismissal was harsh, unjust, or unreasonable, and if there was a valid reason for that dismissal. The terms of serious misconduct or summary dismissal are often interchangeable terms, and it is the most severe form of termination of employment. By its very nature, summary dismissal indicates and records some very serious wrongdoing. Summary dismissal may be implemented without any notice, or it may be also implemented with payment in lieu of notice. Summary dismissal in certain circumstances may also remove entitlements to certain service-related payments, such as accrued long service leave. As I indicated, summary dismissal may also include the payment of notice in the form of payment in lieu of notice. What are the elements of serious misconduct? Was the conduct willful and deliberate by the employee? And was it inconsistent with the continuation of the contract of employment? Another element, did it cause a serious and imminent risk to the health and safety of a person? Did it cause a serious and imminent risk to the reputation, viability and profitability of the employer's business? Did it include theft, fraud, intoxication at work? Did it involve a failing or refusal to carry out a reasonable and lawful direction given by a person of the company who is entitled to give that reasonable and lawful direction? Just going back over those elements, was it willful and deliberate and inconsistent with the continuation of the contract of employment? Did it cause a serious and imminent risk to the health and safety of a person? Did it cause a serious and imminent risk to the reputation, viability and profitability of the employer's business? Did it involve theft, fraud, intoxication at work? And was there a failure, refusal to carry out a reasonable or lawful direction? As I mentioned, all these elements need not apply, only one. If the Fair Work Commission is asked to rule, was there serious misconduct, the Commission will look at whether it was harsh, unjust or unreasonable, and if there is a valid reason, particularly in relation to the serious health and safety of the person. In this case, the Commission might look at the employee's conduct or the capacity, and whether the conduct was willful, malicious or intentional conduct, and whether the conduct in relation to workplace health and safety could imperil or put other employees in the workplace in jeopardy. That is particularly so if the Commission was looking at a safety breach. So in relation to the Commission looking at a safety breach, these are the issues that the Commission would look at in taking into account a dismissal for serious misconduct. The seriousness of the breach or the incident. The company policy setting out the safety procedures and the consequences for the breaches. Relevant health and safety training by the employer. In relation to that, the training records in relation to that training. Whether the incident, the breach, was isolated or reoccurring in nature, and whether or not the employee concerned was a supervisor and therefore expected to set an example. It is interesting to note in relation to this point that a substantial and willful breach of policy will often, if not usually, constitute a valid reason for dismissal. However, a finding that an employee failed to comply with these policies and procedures does not mean that the dismissal was harsh, unjust, or unreasonable. In each case, all of the circumstances must be taken into account. If widespread breaches of policy occur without an employer's response, then this weighs against the decision. The decision was justified and was not harsh, unjust, or unreasonable. Just to recap what the Commission will look for in relation to health and safety breaches: the seriousness of the breach of the incident, the company policies, setting out the safety procedures and the consequences for those breaches, the relevant occupational health and safety training and the records, whether the breach itself was isolated or reoccurring, and whether the person was a supervisor and therefore expected to set an example. If you recall, another element of serious misconduct or summary dismissal involved fighting in the workplace. When considering summary dismissal involving assault or fighting in the workplace, the Commission might take into account the following factors. Generally, the absence of extenuating circumstances. A summary dismissal for fighting will not be a view of harsh, unjust, or unreasonable. Extenuating circumstances include the circumstances in which the fight occurred, such as whether the dismissed employee was provoked or acting in self-defence, and the actual issue at the heart of the incident. The things that the Commission would take into account would be the length of service, including the work record of the dismissed employee, and whether or not the employee was in a supervisory position. The authorities in the case law in relation to this are clear that the Commission must take into account all of the circumstances surrounding the incident and not merely who the aggressor was. Again, the things that the Commission will take into account in relation to assault and fighting in the workplace is the absence of extenuating circumstances, whether the dismissed employee was provoked or acting in self-defence, the actual issue at the heart of the incident, the length of service and the work record, was the employee a supervisor, and the Commission must take into account all of the circumstances surrounding the incident and not merely who the aggressor was. There have been some cases where the employer has summarily dismissed an employee for out-of-hours conduct. It is significant that if an employer is considering terminating an employee for out-of-hours conduct, extreme caution must be exercised here. It is significant that out-of-hours conduct must have a direct and relevant connection to the employment relationship. The conduct must be such that viewed objectively, it is likely to cause serious damage to the relationship between the employer and the employee, or the conduct must damage the employer's interests, or the conduct is incompatible with the employee's duty as an employee. As I've indicated to you, extreme caution should be exercised in this regard. As a subscript to this point, it is only in exceptional circumstances that the employer has a right to extend any supervision over the private activities of an employee. In cases involving out-of-hours conduct, it is insufficient for the employer to simply assert that the conduct will in some way affect the employer's reputation or compromise the employee's capacity to perform his or her duty. There needs to be evidentiary material upon which a firm finding may be made. Conduct outside of work involving criminal offences does not alone warrant summary dismissal. There still must be a direct and relevant connection between the criminal activity and the employee's employment. However, if the employee is unable to attend a significant period because of a serious offence of imprisonment, the employment contract may come to an end due to frustration. I would suggest that you seek the advice of one of the senior workplace relations advisors or your own legal advice before seeking to terminate an employment contract for summary dismissal. There have been a number of cases where an employer has sought to summary dismiss an employee due to loss of trust or confidence. It is insufficient for the employer to find that there is a valid reason for the employee's dismissal simply because someone has lost trust or confidence in the employer's ability to perform the role. There needs to be sufficient evidence and reasoning to support the loss of trust and confidence. As I have mentioned previously, if the Fair Work Commission were asked to explore and examine an employee being dismissed, the Commission would look at the test, whether unfair, unjust, unreasonable, and if there is a valid reason. So relying on a summary dismissal for loss of trust and confidence, that may be difficult to prove. This is a good segue to the next slide, where the Commission is asked to examine a summary dismissal which ends up in, say, an unfair dismissal application or a matter of a general protection. The Fair Work Commission may be asked to examine a decision where a dismissal has occurred, potentially involving serious misconduct. As I've discussed previously, The Commission will look at whether the decision to dismiss was harsh, unjust, or unreasonable, and if there was a valid reason for such a dismissal. To determine whether there was a valid reason relating to the conduct, the Commission must determine whether, on the balance of probabilities, it is more likely than not than the conduct allegedly engaged in by the employee actually occurred. This is known as an administrative test. This is unlike a criminal test, where the test is beyond reasonable doubt. Because this is an administrative test, there is a concept known as the Brigginshaw test, which states the more serious the allegations, the stronger the evidence that may be required. Where serious misconduct is alleged, the test for a valid reason for the dismissal does not change. However, the test for the balance of probability remains the same. But there are three key considerations that must be achieved. And that is, was the decision sound? Is it defensible? And was it well-founded? So again, if the Commission is asked to look at a dismissal, particularly for serious misconduct, it will consider, was the decision harsh, unjust, or unreasonable, and was there a valid reason? It will look at the balance of probability. It will apply the Brigginshaw test, and it will look at, was the decision sound, defensible, and well-founded. The Commission will not stand in the shoes of the employer. And the Commission is basically there to prove that the dismissal was not harsh, unjust, or unreasonable, and that there was a valid reason. The Commission will not decide if the decision is based on reasonable grounds or whether the employee was guilty of the conduct. The Commission has one purpose, and that is to make a finding as to whether the conduct occurred based on the evidence before it. It is important to note that inconsistent treatment by the employer of previous similar conduct by other employees in the workplace is an issue that can be relevant to the final decision made by the Fair Work Commission. An employee's dishonesty may constitute serious misconduct and be a valid reason for summary dismissal. However, dishonesty does not automatically make summary dismissal unlawful, and a single foolish act does not always mean that it is summary dismissal. what are the risks? In relation to terminating an employee for serious misconduct, whether you pay them notice or not, can have both legal or administrative and non-legal risks and repercussions for the employer. There are a number of risks, both legal and administrative. Summary dismissal can result in exposure in the following types of risks or claims. In terms of legal administrative risks, an employer could suffer an unfair dismissal claim, a general protection claim, or an unfair discrimination, unlawful discrimination claim. In relation to an unfair dismissal claim, an employee who falls within the jurisdictional threshold can claim under the Fair Work Act 2009 that the termination of their employment was either substantially or procedurally unfair or both, if it was harsh, unjust or unreasonable. If the employee was successful, and that was found by the Commission, the employee may be reinstated, redeployed, or the Commission may award 6 months compensation in terms of salary to be awarded, and in some cases back pay. It is important to note where the Commission finds in favour of the dismissed employee that the employee needs to prove that they have been unfairly dismissed. In relation to a general protection claim made by the employee, again under the Fair Work Act of 2009, this is where an adverse action has been taken against the employee because they have exercised a protected right in the workplace, or they have been discriminated against. For this reason, it is important that the employer has the evidence to prove that the employer has not taken the adverse action against the employee. In relation to these general protections, the employer bears what is known as a reverse onus of proof. That is, the employer must prove that they did not take the adverse action against the employee, or the employer did not discriminate against the employee. In relation to these general protection claims, compensation is uncapped and penalties may also be imposed on companies and individuals involved in these breaches. As you can see, this is different to the unfair dismissal application, where the amount is capped. In relation to unlawful discrimination, it is similar to general protections. And again, it's important that if the employee believes and can prove that the dismissal was a causal connection between somehow being dismissed because of their race, gender, marital status, or political affiliations, then they may be able to prove that they have been discriminated against. And in these cases, then they may be able to prove that they have been discriminated against and there are costs can be awarded. What is natural justice? Natural justice is at the heart of the process involving workplace investigations and serious misconduct. Essentially, natural justice requires that a person receives fair and unbiased hearing before a decision is made that could negatively affect them. Natural justice is a set of principles that is applied to ensure that all people involved in a workplace investigation are given fair opportunity to be heard, to put their case and to respond to the relevant matters raised. In essence, there are three elements to natural justice. And it's important that the three elements be met: adequate notice, fair hearing, and no bias. Sometimes all three of these concepts are grouped together to the right to a fair hearing. Sometimes the term natural justice is interchanged with the term procedural fairness. So to recap, natural justice is a set of three principles. It's an opportunity to be heard, to put their case, and to respond to the relevant matters raised. There are three main requirements: adequate notice, fair hearing, and no bias. And they're collectively called a right to a fair hearing. And the term natural justice is interchanged, can be interchanged to represent procedural fairness. Before a decision is made, it is important to have the employee respond. So again, in relation to the three elements of natural justice. So before making a final decision, the employer should bring the allegation to the attention of the employee. Give the employee a reasonable opportunity to respond to the allegation. Give the employee the opportunity to present any information that the employer should consider that might influence the employer's final decision. The employer should state that no decision has been made and will not be made until the employer has allowed the employee to respond and the employer consider all information. The employer should consider temporarily suspending the employee from duty, and this is done on full pay. The employer might indicate that while no decision has been made, he or she is considering disciplining the employee, including termination of employment, and the employer is asking the employee to show cause why discipline should not be taken. In terms of natural justice, it is critical that these steps be followed. It is important that you invite the employee to bring a support person to a meeting where you're asking him or her to respond to the allegation. The Fair Work Act does not require the employee to be invited to bring a support person. However, this is considered to be the best practice. The Fair Work Act only requires that a support person be invited to bring a support person. And where the employer reasonably refuses to bring a support person. Remember that the support person is not there to advocate on behalf of the employee. The support person cannot answer questions on behalf of the employee, and the support person cannot participate in any form in the interview, the reason that you might consider suspending an employee is to allow your investigation to take place. It also demonstrates to Fair Work that if a matter goes to Fair Work as an unfair dismissal matter or a general protection, it demonstrates to Fair Work that you have taken the matter seriously. It is important that you continue to pay the employee while you suspend the person. Making and communicating your final decision. Once you have invited the employee to a meeting or given all of the allegations to the employee, it is important that you continue to tell the employee that you have not made a decision and that you need to consider all of the information before you. It is important that you take your time to deliberately consider all of the information and evidence before you make a final decision. Take your time. There is no need to shortcut the procedure. It is suggested that you contact one of the workplace relations advisors to discuss your process and to discuss any concerns before you make your final decision and convey that to your employee. The workplace relations advisors can talk to you around the outcomes and penalties and can assist you in the preparation of your letter. You must convey your final decision in writing to your employee or the respondent. Again, it's suggested, as per Fair Work, that you bring a support person, that you invite the employee to bring a support person to the final meeting where discipline is to occur. You are now ready to make your final decision and communicate it to your employee. Having contacted the senior workplace relations advisors, here is one important question. Have I given the employee natural justice and procedural fairness? You may decide that the conduct is serious enough to meet the definition of serious misconduct, and you may decide to terminate the employment of the employee or the respondent. Terminating the employment. If you decide to terminate the employment, it must be in writing. If it is serious enough, you may terminate the serious misconduct, and it may be done instantly. You have a number of options. You can dismiss the employee without paying the required notice, but you can pay the accrued entitlements, including annual leave, and these need to be paid. The second option is to pay the required notice, and again, the accrued entitlements, including annual leave, need to be paid. This is my preferred option, to pay the required notice and, of course, the entitlements. The critical question. With any summary dismissal of serious misconduct, remembering that if the matter goes to Fair Work, these are the questions that Fair Work will examine. Was the dismissal harsh, unjust, unreasonable, and was there a valid reason? These are questions that you should ask yourself before you proceed. If you can answer these questions, that the termination was not harsh, unjust and unreasonable, and you had a valid reason, you should proceed with the termination letter. The termination letter should include that the employer has considered the response to the show cause and made a final decision. You as an employer find that the employee has engaged in serious misconduct. You have made a decision to terminate the employment. The effective date of termination of the employment, immediate, and that is in the day of the letter. If notice is to be paid, paid in lieu of working, no notice to be paid, that the final pay, including accrued but unused entitlements, will be made and paid into the bank account held currently and paid within 7 days from the date of the letter. Again, to recap, the termination letter will include that the employer has considered the information provided at the show cause by the employee and a final decision has been made, that the employer finds that there has been serious misconduct, the decision has been made to terminate the employment, the effective date of that termination, it could be immediate, whether notice is to be paid in lieu or no notice to be paid, that a final pay will be made, including accrued but unused entitlement, and that the final pay will be made into the bank details held within 7 days from the date of the letter. As you can see, we have considered a vast array of information in relation to serious misconduct and summary dismissal. I will wait for a few moments to see if there are any queries coming in that I can answer. Alternatively, please feel free to send your queries to us at the information provided on this final slide. The presentation, together with the recording of the webinar, will be available through the MTA Queensland portal, there appears to be no questions coming in, and with that I'll end the webinar, but please feel free to contact me either directly or sending your queries to the email address or at the telephone number provided. Thank you for your participation today, and I look forward to your further inquiries.